Hello, welcome to Cloud Security Alliance webinar series, Cloud Bytes. Today's Cloud Byte is entitled Privacy Level Agreement Code of Conduct for CSPs, a compliance tool for GDPR. Our presenter is Mr. Nicola Franchetto of ICT Legal Consulting. As with all CSA Cloud Bytes, during this live presentation, you will have the opportunity to submit questions at any time. Just use the question tab at the bottom of your screen. Time will be reserved toward the end of the webcast to address these questions. The slides from this webinar will not be provided. However, you can access the recording of this webinar at any time. Just use the same link to view the webinar again. Now, please, let me introduce to today's presenter, Nicola Franchetto. Nicola Franchetto is a qualified ICT privacy and data protection lawyer. He's a senior associate and data protection officer at ICT Legal Consulting. He obtained his Master of Laws cum laude in Information Technology and Intellectual Property at the Institute for Legal Informatics at University of Hanover. Franchetto possesses a very strong expertise on data security and information technology. Effectively, he operates in ICT Legal Consulting as man in the middle between the legal and the IT practical aspects related to personal data processing, cloud computing, big data, analytics, and Internet of Things are areas in which he has developed significant experience. He is also a fellow of the European Privacy Association in Brussels and the Italian Institute for Privacy in Rome. Thank you again for joining us. Nicola, hello. I am going to turn it over to you to start presenting.
Thank you, Marina. Hi, everyone. I hope you can hear me well. Today, as Marina said, we will talk about the Privacy Level Agreement Code of Conduct. It's a compliance tool, as you may read from the slides, which actually enable any customer using cloud customer providers to assess the security and the organizational measure that any cloud service provider is implementing. So it is basically both a compliance tool and a document which analyze different aspects of cloud security services in order to make informed decisions. Firstly, I will introduce who is CSA, which is the Cloud Security Alliance, which is the component of, is composed by different service providers throughout the world, and it provides security and services to professionals and companies together with data protection authorities. It's a global no-profit organization. There are more than 65 chapters, which are basically the nation in which CSA is present. Building best practice standards, identify a key foundation of functioning of cloud economy, champions of interoperability, enable innovation, advocacy of prudent public policy. They provide research, they advise government and private companies, they provide education and professional certifications such as the CSA STAR program. They provide standards and they used to present in events such as the Cloud Security Expo in London and all throughout Europe and in the world. Today we will talk about the PLA Code of Conduct. As I said before, this is a compliance tool which allows any customer who wants to move to the cloud and any cloud service provider to declare what are the organizational and security measures, what are the retention policies in order to comply with the GDPR. So as you know, or maybe you're not from Europe, so you're not aware of this, in April 2016, the General Data Protection Regulation was enacted, and in May 2016, the text was published. Other than before, this is a regulation, so if you're not confident with the EU legal framework, regulation is applicable uniformly all throughout the 28 member states. And the broader territorial scope of this regulation is far more broader than before. Because if you have a look at Article 3 of the GDPR, it states that the GDPR applies where processing takes place in the context of the activities of an establishment of a controller or processor in the EU. And it applies as well to controller outside the EU when the processing activity relates to the offering goods or services to data subjects in the EU, or when it deals with monitoring the behavior of data subjects in the EU. So it doesn't matter if you are an organization established in the EU or in the US, in South Africa, or in Japan. To the extent that you are dealing with individuals in the European Union, you will still have to apply the GDPR. It doesn't even matter if you are offering services or goods free of charge, such as an online services, because to the extent that you are addressing individuals in the EU, you will have to apply the GDPR. So for certain experts in Europe, this is more a competition law than data protection law, because it obliged US companies, for example, who in the past were stating, no, we are in the US, we are not applying the European Union law because our data processing takes place here. Starting from May 2018, more precisely 25 May 2018, they will have to apply the EU law, meaning the GDPR. This is the scope, the territorial scope of the GDPR, but we have three main game changers which were not present in the previous Directive 95/46. The first game changer is the principle of accountability. What does that mean? That the controller shall be responsible and be able to demonstrate compliance with all the principles relating to data processing of personal data. More in general, Article 30 of the GDPR says that if you are a controller or if you are a processor, you will be responsible for any processing and any security measure that you are implementing in your own organization. So other than before, there is no more a prescriptive law which states what you have to do. It's you as a business who has to define your own security measure, your own processing activities, and define the security level that you want to implement for those processing activities in order to be compliant with the GDPR. So in case of inspections from the supervisory authorities, wherever you are established or not, as I said before, in the EU, you will have to demonstrate that you have made informed decisions regarding the processing activities that you are dealing with. So the second point is that the GDPR is risk-based. So you are requested, as I said, for the principle of accountability to determine the appropriate level of protection on the personal data. And there are certain factors that you will have to take into consideration, and these factors are spread all throughout the GDPR. So you will have to consider the state of art, the cost of implementation, the nature, the scope, the purposes of processing, as well the risk of varying likelihood and severity for the rights and freedom of natural persons. So wherever you are processing sensitive data, wherever you are processing judicial data, wherever you are monitoring employees in order to assess their performance, wherever you are an insurance company and you want to monitor the behavior of your clients in order to assess the risk of their insurances, you will have to be responsible for declaring and implementing appropriate security measures in order to demonstrate to the supervisory authorities that you are compliant with the GDPR. The third game changer is sanctions. Other than before, sanctions can reach the 4% of an undertaking's total annual worldwide turnover, or 20 million euros, or or £70,000, more or less. The fourth game changer, which is still in the third, sanction and enforcement, there are new rights for data subjects. So other than before, data subjects are not simply allowed to request to the data controller to have access to their own data, but they may have as well the right to bring a legal action before the supervisory authority, which is competent for the case. And more than this, non-profit organization can be mandated by data subject to lodge a complaint and claim compensation on their behalf. So the GDPR introduces the class actions. So wherever you are a data controller or a data processor, you must be aware that starting from the 25 May 2018, you may face a class action on the processing activities that you are pursuing. And other than before, there is a joint liability of controller and processor. So if you are creating a damage to certain data subjects and they brought you before the supervisory authority or before a judicial court, you may be obliged to pay compensation, regardless whether you are a controller or regardless whether you are a processor. The only discriminate will be the data processing activity, the data processing agreement, and the contractual agreement that you have between controller and processor. These are the only legal binding documents that can determine how liable you are for the processing activity that you are carrying out. What is the purpose of the PLA code of conduct? If you have a look at Article 40 and 41 of GDPR, the EU legislators stated that you may demonstrate compliance by signing a code of conduct or a certification mechanism. Both the code of conduct and certification mechanism need to be approved by the relevant supervisory authorities. And this is what the PLA will face, basically, because with Paolo Balboni, which is the chair of the working group of the PLA and the founding partner of the ICT Legal Consulting, the law firm for which I am working for, they provided a draft of Code of Conduct, which will be soon presented to the Article 29 Working Party, which is the assembly of all national data protection authorities, in order to get that approval. The same PLA Code of Conduct has been drafted together with components of the data protection authorities. So we are quite confident that the working party will soon approve this code of conduct. And we are confident of this because we had a look of other code of conduct regarding cloud service providers, which has been published recently, such as the Cloud Industry Security Group or the CISPE for the software as a service providers. So other than these code of conducts, we are quite confident that the PLA resembles the opinion of the Article 29 Working Party and resembles, without lobbying efforts, the text of the GDPR. So the scope of the PLA is ensuring transparency and compliance to the law. So regardless whether you are a customer of cloud services or if you are a cloud service provider, you will have at the end of the code of conduct, as I will show you later on, you will have to complete an Excel spreadsheet in which you will declare 15 points regarding data processing operation, which will actually be able to demonstrate what are your policy regarding data protection law. So let's go into the PLA Code of Conduct. As you see, we reported certain statements from the Irish Data Protection Commissioner and the President of the French Data Protection Authority, who actually read the previous PLA version 2, and stated that this was a good tool that had to be accepted by cloud security providers because that was a good tool in order to demonstrate compliance. So first of all, let's explain what is the goal and the methodology that we followed in order to create this code of conduct. The goal is provide the cloud service providers a tool to achieve compliance, to demonstrate compliance through certification with the GDPR. So if you are actually able to complete the 15 requirements of the code of conduct, you will actually be able to demonstrate that you are compliant with the GDPR. So it's a tool which enables you passing from the previous data protection regime to the new GDPR. The second is addressed for customers, cloud customers. So with this tool, you will actually be able to assess whether your cloud service provider is actually complying with the GDPR. So you may actually send the annex, the Excel spreadsheet, to different cloud service providers. They will have to complete the 15 requirements declaring what are their data protection policies, and you will actually be able to assess and compare the answers in order to make an informed decision regarding data protection law. The scenario is B2B. We know that most of cloud service providers are dealing with customers, but in this regard, we mainly focus with the B2B framework. It is also true that if you are in a B2C relationship, the 15 requirements of the code of conduct may reasonably be used as a way to declare what are the data protection policies that a cloud service provider will implement, and to assess whether those answers actually satisfy the customers, so you in certain cases. The code of conduct is aligned with the GDPR. As I said before, is strongly based on the Article 29 Working Party opinion with the ENISA guidelines. For those who are not confident with you, the ENISA is the European Agency for Information Security. And it's also based on ISO standards, in particular 27001 and 27002. And it considers differences between whether the cloud service provider is a controller or a processor. So if you will have a look at the code of conduct, you will see 15 requirements, and in each of these, there will be certain tasks that has to be fulfilled by the cloud service provider when he is acting as a data controller or when he is acting as a data processor, or both in certain cases. So the first requirement of the code of conduct is making a declaration of compliance and accountability. So in order to give you an explanation, a full explanation of what that means, is basically the cloud security provider has to make a statement that he's compliant not only with the GDPR, but also with the code of conduct, which is aligned with the GDPR. This will give you an assurance that he has declared, at least contractually speaking, that he has implemented certain security measures and certain organizational measures without actually declaring what they are. In certain cases, this is justified because cloud service providers do not want to disclose certain information regarding security. In some others, they simply do not want to go through a third-party certification process. You have to know that the code of practice, the code of conduct, can be assessed through a self-certification, which is mainly declaring that you are complying with the code, or through a third-party certification, which may also be a qualified PLA certification mechanism, such as the CSA STAR program. So the first thing that you have to declare when you want to compile or when you want someone else to compile the code of conduct annex is, are you actually able and are you actually willing to declare that you are compliant and accountable for what is stated in the code of conduct? In this certain sense, you will have a first assurance that someone is making an accountability statement, so he will be liable for what he is declaring. The second point is for the CSP. So you will have to know who is the CSP. If you have a contact person, which is not usually a person from marketing and sales, usually is a data protection officer of the cloud security provider, to which you may address all the questions, all the requirements that you want to have, that you want to address. So in case the annex is not actually completed, you will have a point of contact to which you may address your further question. And precisely, what is the role? I see a question, Peter Van Eyck here. I came in late because of technical issue. Is the PLA free published already somewhere? Unless Marina has a different answer, I believe not. Right, Marina? Marina, she is probably mute. Okay. Any case, Peter, I will reply at the end of the session, so you will have the answer probably as well from Marina. The third point, ways in which the data will be processed. So when you are required to compile this requirement, you are actually forced or obliged to disclose where you are processing data, so the precise location in which they are processed. So if you have affiliates or parent company which will actually be able to view process data, Marina, probably you should put yourself in mute. Okay. Can you put in mute? Otherwise, maybe. Okay, thank you. The second point regarding requirement 3 is, are you actually using subcontractors? Article 28 of the GDPR says that if you are a data processor and you want to implement other sub-processors, you will have to receive a general or a specific written authorization in order to use a sub-processor. So let's take as an example probably the most famous cloud service provider in the world, Microsoft, and in particular Office 365. If you have read the terms and conditions of Office 365, you have probably saw that Microsoft is actually using different, and it's quite a lot of sub-processor in order to perform Office 365. So, for example, they will disclose data, or in any case, they might see data from Ireland, from the US, from South Africa, from different parts, from different affiliates of Microsoft all throughout the world. And if you are the data controller, therefore the person in charge of deciding the purposes of data processing, you will have to be aware in advance that Microsoft is actually using sub-processors all throughout the world. Also because you need to regulate data transfer, especially if you are in the EU and you want to transfer data abroad, you might need to use one of those transfer mechanisms provided for by the GDPR, such as binding corporate rules or standard model clauses. So the third requirement actually demands the cloud service provider to declare how do you process, where and how do you process personal data. Point 3.c actually required the cloud service provider to declare if it's going to install software on cloud customer systems. It may be an add-on for the browser by maybe someone else. So in order to demonstrate compliance, the client, which is usually the data controller, needs to be aware how do you process data, and are you actually using other means that I'm not aware of or that I'm not yet aware of that will actually allow someone else to use my own data? I'm not sure if you are aware of Zendesk as a CRM chat. You might not be aware that sometimes Zendesk actually requires you to install a program in order to take advantage of cloud service providers, of cloud services. So in this case, the cloud service provider is obliged to declare if it's going to install software in order to use its services. The fourth point regarding requirement free is data processing contract or other binding legal act. This is a requirement that actually needs to be satisfied in order to demonstrate compliance with Article 28 of the GDPR. As you know, any data processing operation, when it comes to data controller using other external data processor, has to be regulated through a contractual agreement, a legal binding act, as it is stated in Article 28. This data processing agreement or this data processing contract needs to have all the requirements set forth in Article 28, paragraph 3. So the data controller needs to be aware, together with the data processor, of what kind of data is the processor actually processing. So is this just common personal data? Are there special categories of data, such as data relating to health, genetic data, trade union data, or are they actually judicial data? In the last few weeks, most of cloud service provider has published new tools allowing their own customer to demonstrate compliance with the data they are storing in their own service, in their own servers, such as Rackspace or Treasury. They actually made a dashboard which allows customers to regulate privacy requirement and privacy operation regarding their own data. This data processing contract actually define other aspects regarding data processing activities, such as what are you going to do with my own data at the end of the contract? Are you going to delete them? Are you going to anonymize them? Maybe you're not aware of, but certain cloud service providers do not delete your data. They basically anonymize your data so that they are no more personal data, and they made analytics or statistics regarding your own data in order to provide other services. There are many players doing this business because it relates to the big data business and not actually using personal data. Therefore, the GDPR is not applicable. I'm simply anonymize the data of someone else, and I'm using them to improve my own services or to provide other services to third parties. So in that data processing agreement, the cloud service provider will have to disclose what he's going to do with your own data. And this is just one of the requirements set forth in Article 28. The fourth requirement regards record keeping, regardless whether you are a cloud service, regardless whether you are a data processor or a data controller. If you have a look at Article 24 of the GDPR, it states that because of the principle of accountability, any data controller and any data processor has to keep a record of processing activities in which you declare what are the purposes that for processing data, what are the security measures, who are the person on behalf of which you are doing that processing activity, such as when you are a data processor and you are providing services to a lot of clients. Think about if you are a cloud security provider and usually you are a data processor, you will have to keep a processing activity record in which you will have to declare for each of your clients which kind of processing activities you are doing, on which data, what are the security measures, and for how long you are keeping those data. The requirements are quite clear, and they are defined at Article 24 of the GDPR. Requirement 5 relates to data transfer. Data transfer is regulated from Article 44 and Article 49 of the GDPR. It basically says that if you are moving data from the European Union, and more specifically from the European Economic Area to abroad, you will actually need to implement security and contractual measures in order to demonstrate that you are compliant with the GDPR. We all know that before, during the applicability of the Directive 95/46, you could use the adequacy decisions provided by the European Commission, or the standard contractual clauses, or the binding corporate rules. Article 44 to Article 39 merely replicate the previous transfer mechanism that you may use in order to transfer data. But the Code of Conduct actually requires the cloud security provider to declare specifically what are the legal basis in order to the transfer of data to outside European Economic Area. So let's go back to the previous example I provided regarding Microsoft Office 365. If you have read the terms and conditions, you will read that you will have to sign the standard contractual clauses with Microsoft Corp in the US in order to allow the transfer of data from the European Union to the US when you are using Office 365 services. And by requiring your cloud security provider to compile, to fulfill the Code of Conduct, you will actually become aware of what are the transfer mechanisms used by the cloud service provider. The sixth point regard the data security measures. So as you know, Article 32 states that in order to demonstrate compliance, and because of the principle of accountability, you will have to implement security measures which are assessed regarding the risks for data subjects, regarding the state of art, regarding the cost of implementation, regarding the further improvements of technology. So to demonstrate that you are actually aware of the security measure you are implementing, and these security measures are actually good for the processing that you are carrying out. So you will have to demonstrate by means of these security measures that you will actually be able to demonstrate availability, integrity, confidentiality, transparency, isolation, intervenability, and, other than before, portability. What is portability? We will talk about portability later on because it's one of the requirements of the Code of Conduct. I will merely anticipate what does that mean. Before, or other than before, therefore, the General Data Protection Regulation has introduced a new right for data subject, not only the right to be forgotten, which is quite well known so far, but the right to data portability. So if you are a data controller, you might be obliged on request to transfer data of one of your clients to one of your competitor. So I could be a client of Rackspace, for example, and I could ask Rackspace to move my data in a machine-readable format without hindrance to one of Rackspace competitor without Rackspace having a word on this request. And this is one of the new rights provided by the GDPR, which has been introduced in Article 20 of the GDPR. Moving on, the seventh requirement regards monitoring. The cloud security provider, let's say, has to declare if it provides monitoring services for its own client, for example, access log, dashboards, or other ways which allows the customer to have a view of who has access to its own data. So the cloud service provider needs to implement a dashboard or anyway a tool which allows to register each access log, each permission, each segregation of access that he can create by its own in order to allow customer to have its own personalized configuration of services. And by compiling the code of conduct, the annex, the Excel spreadsheet, the cloud service provider will actually be required to disclose if it provides such features. And if it doesn't, you will actually be able to make an informed decision and a comparison with other cloud service providers. The eighth requirement, which is also really, really important, regards the personal data breach. If you have a look at Article 33 and 34, each data controller is now obliged to disclose to the supervisory authority within 72 hours if it had a personal data breach, meaning that someone intentionally or not had actually access to your data. So by requesting the cloud service provider to compile Annex 3, it will actually be obliged to disclose what are the security measures and what are the incident management policy that the cloud service provider has in order to allow you, usually by you, I mean the customer, which is usually the data controller, to comply with the Article 33 and Article 34 of the GDPR. So basically, I want to know what are the security measures and what are the incident management policy that my cloud service provider has in order to help me to disclose if I had a data breach to the supervisory authority whenever it happens. And this is quite important because sanctions in the GDPR are only upon the data controllers. You may go back to the data processor by contractual agreements, but when the supervisory authority finds that there's a breach of the GDPR, of one of the provision of the GDPR, the only responsible for the sanction will be the controller. Therefore, you do really want to know what are the incident management response of the cloud security of the cloud service provider. The ninth requirements regard data portability, migration, and transfer back. What that means, as I said, Article 20 of the GDPR states that data subjects have a new right to data portability. So if the data processing is based on consent, they can actually require the data controller to move their own data to someone else or simply merely to download their own data in a machine-readable format in order to transfer them to someone else in the future. So as I said before, you might find you need to demonstrate compliance. You need to demonstrate that you have actually the means in order to transfer data belonging to one data subject to someone else in a quite short period of time and without hindrance. So far, the Commission has not provided clear guidance regarding data portability. Only the Article 29 Working Party has provided guidelines back in April of this year regarding data portability, but they have not yet defined the technical means to comply with data portability. Most of the European Commission members are actually thinking about the application program interfaces in order to move data from one data controller to another, but so far we have not yet the technical means or anyway a technical guideline which allows data controller to implement certain mechanisms to move data from their own servers to another servers or competitor servers. Migration relates again to data portability. You may not only require to transfer personal data from one from one data controller to another, but you may also be required to transfer other data belonging to the data subject to one part to another. And the transfer back, as I said before, at the end of the processing activity, at the end of the master service agreement, what is the cloud service provider doing with your own data? Is he actually deleting them? Is anonymize them? Is going to simply, as I said, anonymize those data and make money by using using them in its algorithm of big data in order to provide other services to other parties? This is something really important that you need to know, because if it's simply deleting or giving back the data, your personal data, this is perfectly fine. But if it's actually anonymizing them and then is going to make money out of statistical or analytics, you may actually demand a discount for the money you're actually giving to the cloud service provider, because it's actually making money out of the anonymized data he's actually processing. So this is also quite important to know when you are assessing a cloud service provider. Coming to requirement 10, restriction of processing. This is another right which has been defined in the GDPR, Article 18. A data subject may require you not to delete its own data in case of illicit processing, but it may require to freeze its data. Therefore, you have only to store them. In the meantime, it's actually complaining to the supervisory authority for the illicit processing it's doing. So the cloud service provider has to demonstrate that it can move the data of one data subject to a safe store, to a safe server, a separate server, in which data is only stored without any other processing activity. This is also important because the data controller is responsible for compliance with the restriction of processing, therefore with Article 18 of the GDPR. Requirement 11 demands the data retention, restitution, and deletion. As I said before, the cloud service provider has to demonstrate for how long it's going to keep your own data or someone else's data. So is it actually doing backups or recovery plans? Therefore, your data will be stored far more than the duration of the master service agreement. How long is going to keep data? He's actually obliged to keep data for a longer time because it's established in a member state in which there is a law that data has to be kept for at least 10 years. You have to be aware for how long data will be stored. Therefore, the cloud service provider has to disclose this information. The requirement number 12 relates to cooperation. You want to know if the cloud service provider is actually providing assistance in case of a law enforcement agency is going to make an investigation on the cloud service provider on your own data. In case the supervisory authority is making an inspection on the data controller and you need the assistance of your processor, which is usually the cloud service provider, you need to know, you need to be aware what are the cooperation, what are the tools, what is the assistance that the cloud service provider is going to provide you. And this is requirement 12. Requirement 13. There might be, as I said, a law enforcement agency which has received an order to assess data, your data stored in a cloud service provider servers, or your own data in case you are a cloud service provider and you are dealing with your own data as a data controller. In this case, you want to know if the cloud service provider is actually able to comply with this law enforcement orders, if he's actually assessing them properly. So by requiring the cloud service provider to disclose how he's going to deal with legal orders, with court orders, you will actually be able to have an informed decisions regarding whether using that cloud service provider or another. What if, for example, a data breach occurs because of the cloud service provider? This is requirement 14. You want to know what are the remedies, the civil and criminal remedies that you may have against the data processor, or the cloud service provider wants to know what are the remedies that it can and it cannot give to its own customers in case something occurs because of its own fault. And Article 14 gives you the opportunity to know and to assess the cloud service provider responses. The last requirements relate to the cloud service provider insurance policy. This is not provided by the GDPR. We wanted to introduce requirement 15 because most of the time the cloud service provider is a data processor. He's not a controller. Therefore, he processes data on behalf of its customers. It cannot decide its own purposes regarding customers' personal data. Therefore, when it comes to a data processor and you are the data controller, you are the end client, you want to make sure that in case of something goes wrong, in case of a breach of the systems, in case of a provision of the GDPR has not been fulfilled, you will have an insurance to rely on, and the cloud service provider has a cyber insurance in case something occurs to your own data. And this is why, because, as I said before, sanctions of the GDPR are upon the data controller. And in most cases, the cloud service provider is a data processor. So you want to make sure that in case you will have to pay 20 million euros for a sanction, for a breach that has occurred because of the data processor, you will have a contractual agreement, you will have an insurance to rely upon in case something goes wrong. This is not, as I repeat, this is not provided by the GDPR, but it's still something really important, and probably the most important part, the most important requirement that you want to assess regarding our cloud security providers, because if something goes wrong, you will have a remedy, you will have an insurance to which you can rely upon. And this is, I guess, the end. The last slide relates to the PLA table Annex 1. This is, as I said before, the Excel spreadsheet, which will be included in the cloud, in the code of conduct, which is basically the file that you will have to fulfill, or that you will have to send to your cloud service providers in order to assess their capability to demonstrate, to be compliant with the GDPR. And this is done, I guess. Yes, the last part is about the governance. As I said, the code of conduct is based on 15 requirements, which we have just explained. The last one relates to the governance. The governance is made by a PLA working group and an open framework, an open certification framework group, which are actually responsible for making sure that the PLA is always compliant with the GDPR. As we know, the GDPR is a regulation. It will be implemented to the same extent in all 28 member states, except certain small, I would say, minimal parts, such as the employment law or criminal law, which are still based on national law and not on the EU law. But the PLA working group is actually in charge of deciding and updating the code of conduct in order to demonstrate compliance with the further specification, the further requirements, which will be issued soon by the national data protection authorities or the European data protection authorities. So there is an organism in order to make sure that each time a new requirement, a new guideline has been published, the PLA will be updated in order to demonstrate that those signing or self-certifying their compliance, they will be actually compliant, sorry for the repetition, with the GDPR. And this is banned. I've seen we have questions, probably Marina can answer to this question. And most of them relate to when the PLA3 will be published, will be publicly available. So Marina, probably I have the draft, but I'm not that sure if it is yet online or not. Can you actually reply to this question?
Yes, thank you, Nicola. PLA version 3 will be publicly available, but not yet. Right now it's in peer review process, and as soon as that is finished, it will be published on the CSA website, probably around end of September, October. There will be an announcement made. So, yes. I guess we can go on with more questions on the presentation. Nicola? Nicola, can you hear me?
Yes, sorry, Marina, I was mute. If there's any question that you want to have, I'm quite sorry, to be fair, that the draft of the PLA is not yet available, so you simply relied on my own word and explanation of the PLA, but as Marina said, it will be published soon. What it is interesting about what I believe should be a question, but maybe you already know the answer, or maybe I've already replied to the question, relates to the territorial scope of the GDPR. So let's put apart the PLA, which is a tool in order to be compliant with the GDPR, when the GDPR is applicable. The GDPR, territorially speaking, is applicable whenever you have an establishment in the EU and whenever you are addressing EU citizens with your own goods and services, or regardless whether you are monitoring or assessing the behavior of European citizens in the EU. I want to make sure that you actually understand this, because most of the time it's not clear. An establishment could be merely an agent in the EU which is actually in charge of data processing activities. If you have the opportunity, please read the Weltimo case of the European Court of Justice of the European Union, in which it has been stated that you will have to, you can actually be required to apply the GDPR even if you are not established in the EU. And even if it is simply an agent in Poland or in Hungary, you may actually be obliged to comply with the GDPR, because an agent processing data in Europe is an establishment according to the GDPR. If you have a look to another important case, which is the right to be forgotten, the Google Spain case, Google Spain was not actually involved in the processing of personal data, because the processing took place in the US thanks to Google Inc. But Google Spain was the means by which Google Inc. could provide services in Spain. Therefore, an establishment is a really, really broad definition that you need to be aware of when you are considering whether you have to comply with the GDPR or not. I have another question. How soon, when do you envision GDPR goes into effect and became applicable? How long will CSPs have to comply by this law? The 25th of May, 2018. So I'm not saying that you are quite late, but actually you are, because you have less than 280 days in order to be compliant with the GDPR. This is quite sure. The Information Commission officer in UK made it clear this week that regardless the sanctions, he will not wait the 27th or the 29th of May in order to apply the GDPR. Starting from the 25th of May 2018, each data controller, each data processor processing data in Europe or regarding European citizens will have to comply with the GDPR. This is quite important that you have that. This is quite important. So the first thing you have to assess, you have to talk with the management in order to make an informed decision regarding if you have to demonstrate compliance with the GDPR, is taking Article 3 and seeing whether you are actually in one of those situations. I may give you examples regarding I made an example regarding what establishment means according to the EU law. I made another example which relate mainly to cookies and basically to monitoring behavior of individuals in the EU, of people in the EU. So think about the example. I'm a data controller in Argentina. I made available a website for EU citizens, and I'm actually using Google Analytics and other profiling cookies in order to assess the behavior. Am I actually obliged to comply with the GDPR? Yes, because as you have seen at the beginning of this presentation, the broader scope of the GDPR includes as well the monitoring of behavior of citizens in the EU. So even if you have an application, a mobile application stored on the Google Play or on the Apple stores, and that implements SDK, for example, which actually are used for monitoring the behavior or monitoring the performance of the application, you will still be obliged to comply with the GDPR. As you see, the monitoring the behavior of data subjects in the EU or offering goods and services to data subjects in the EU. So, or again, if you have an establishment in the EU, or in all these cases, you will have to comply with the GDPR. Is there any other question that you want to? Otherwise,
yes.
I'm finished, Marina. Oh, Article 78.
Thanks.
We have another question. Article 78. A processor shall be liable for the damages caused by processing only where it has only complied with obligation with the regulation specifically directed to processor acting outside or contrary to lawful instruction controller. Does this imply that a processor breach of code of conduct, they will be liable for any damage caused? It depends on the data processing agreement that you have signed.
Hello, Nicola? Nicola, I cannot hear you. Anyway, we are running out of time. The presentation will automatically close in a few minutes. So I'd like to take the chance to thank Nicola so much for taking the time to present today. Yes?
Yes, I'm sorry. The line dropped off.
I understand. It happens. Thank you. Do you have anything to say more on the previous questions?
No, it depends. As I said before, it depends simply on the data processing agreement that you have signed, which is the only contractual means that you may use in order to demonstrate that you may not be liable for the damage that has occurred to a data subject.
Okay. Thank you again, Nicola, for presenting today. Concluding, I'd like to say that the recording of this webinar will be available within minutes of the conclusion. Simply use the same link to rewatch. You can rewatch this webinar, other recorded webinars, or sign up for new ones by going to cloudsecurityalliance.org/research/cloudbyte. You can also subscribe to this channel to stay up to date on all things cloud. CSA is an approved ISC Square CP submitter. In order to have CP submitted on your behalf, please submit your member ID number in the text box on the right-hand side of the screen. Lastly, if you have any additional questions or you are a CSA corporate member and would like to schedule your own Cloud Bytes, please email the Cloud Security Alliance research team at research@cloudsecurityalliance.org. Thank you for attending today's Cloud Byte webinar and have a great day. Bye.